Okay, so this is my brief outline for Color of Justice, Chapter 3. So in the chapter, she starts off by giving the example of Irma Faye Stewart, who was a 30-year-old single mother who was African American, and she got arrested in a drug sweep, right? So she's innocent. She wasn't in possession or selling or anything of that nature. So after a week in jail, they talk about it in the book how it was her entire apartment complex that was in this drug sweep. So after a week in jail, she's eager to get home to take care of her kids, but her court appointed attorney urges her to plead guilty to distribution. So at first she refuses to do so because she knows she's innocent, right? So then after, that was the first week when her lawyer tried to get her to plead guilty. But then it had already been 3 weeks, she's coming up on a month. She decides, you know what? She needs to get back to her kids. She needs to get back to her job. She's a single mother. She doesn't have the kind of support that she needs to make sure her kids are taken care of. So it's been almost a month. She's been in jail. She takes the plea deal. She gets back home to her family, and she receives 10 years probation and $1,000 in fines, plus court and probation costs. And, oh yeah, before I get on to Clifford, but really, she gets branded as a drug felon. So as a result, she's no longer eligible for food stamps. She can't vote for 12 years. She's discriminated away from jobs. She's evicted from public housing. This causes her to become homeless, and that results in the loss of her child custody, meaning that, she ends up losing the kids that she actually pled guilty in order to get to so she could support them. Right? So it really kind of shows how this system can sweep people into it. She uses Irma Faye as an example of that. So really what happens is for those people who didn't plead, who didn't take the deal, they basically they go in front of a judge. It's been over a month. He eventually dismisses all charges against them because the sweep was based on a faulty testimony from one informant. So now, she's vindicated, right, Irma Faye, in her innocence, but it's too late. She already pled guilty to a drug felony, so now she's homeless and she can't get her kids back. And then she gives the example of Clifford, who, his story is so sad. So he returned to his home in Bryant, Texas, to attend the funeral of his 18-month-old daughter. But before he could get to the funeral, he was detained by police, and they refused him the opportunity to go to his daughter's funeral, or just to even see her before they buried her. So he was told by prosecutors that he had to testify against a defendant in a recent drug bust. But when he said he didn't see the incident, so he couldn't testify to it, he was charged with refusing to cooperate. And then they said they would indict him on felony charges. So after a month in jail, all of the charges were dropped, but his life was negatively impacted, right? Because in that month that he was in jail, he lost his job, he lost his apartment, and his furniture was all repossessed due to his incarceration. So although he was not able to go, he was ultimately let out, he wasn't even able to go to his baby daughter's funeral. So this is a quote from the book. In every state across our nation, African Americans, particularly in the poorest neighborhoods, are subjected to tactics and practices that would result in public outrage and scandal if committed in middle-class white neighborhoods. In the drug war, the enemy is racially defined. So again, she's using the examples of Irma Faye and Clifford to illustrate her point, what she's making here of how people get swept into the system. So, she talks about how the system itself is structured to be race neutral. We're told that the war on drugs is a war on a thing, right? It's a war on drugs. But in this chapter, Alexander's arguing that the war is really against a group of people. So according to Human Rights Watch in 2000, in 7 states, African Americans made up to 80 to 90% of all drug offenders sent to prison, while in 15 states, black people are imprisoned on drug charges 25 to 57 times more than white drug users. So, enter the war on drugs. Within 3 years, prison admissions of African Americans skyrocketed, quadrupling in number. By 2000, the number of people incarcerated was more than 26 times the rate it was in 1983. 22 times as high for Latinos, and 8 times higher for whites. 3/4 of the imprisoned have been blacks and Latinos, while the majority of illegal drug users and dealers are white. The surveys that have been conducted so far show people of all races using illegal drugs at remarkably similar rates. And drug markets reflect racial and socioeconomic boundaries, that it's most users that buy drugs locally from their own race, because we lived in such, we live in a very racially segregated time where most neighborhoods are pretty racially segregated. Yet in 2006, for example, 1 out of every 14 black men who was incarcerated, compared to 1 in 106 ratio for white men. So 1 in 14 versus 1 in 106, you can see there's clearly some sort of racial bias going on there, and a lot of what she's arguing is that this bias is coming through drug war practices. So she argues the Supreme Court has a big role in this too, and she's going to get into a lot of specifics of the cases later on. But she's saying, the Supreme Court has made it easier for the system to discriminate, and it's made it harder for defendants to make legitimate claims that they are facing racial discrimination. And the structure of the system itself is the source of the problem, according to Alexander. So, there's a quote again in the book. She uses, quote, "Despite the colorblind rhetoric and fanfare of recent years, the design of the drug war effectively guarantees that those who are swept into the nation's new undercast are largely black and brown." Because like they said, obviously there's a growth in the proportion of all people that are incarcerated. But the ratios are so disproportionately different that if you live in a certain state, you could be 57 times more likely to go to prison because of your race. That's incredible, right? Okay, so there's racial disparities kind of all throughout the system. First, law enforcement methods tend to lead to disproportionate rates of people of color being incarcerated, such as racial profiling, stop and frisk policies, where police are able to kind of just determine who, quote unquote, looks deviant or looks criminal. And of course, it's not as if only police have these perceptions, right? We're all socialized to believe that certain groups in society are more scary, criminal, deviant than others. And it's not necessarily our internal perceptions that come from us. It's more something that we've soaked up through the culture. Of course, she talks about how the system itself operates and pretends to be kind of colorblind and separate of race. So there's a perception that if there's higher rates of African Americans incarcerated, that reflects more criminality on behalf of the group. So this is very common, right? People will look at the statistics and say, well, more people of color are locked up in prison, so they must be more criminal than white populations. When we look at the actual studies of, victimization studies, research on offenders, we find that actually when it comes, especially drug use, that's pretty split across racial groups, right? That's pretty evenly distributed. But the people that are being swept into the system are disproportionately low-income people of color. So again, it's taken out of context of police methods and racial residential segregation, meaning we tend to live in pretty racially segregated areas. So if police are going to do hotspot policing where they hyper police certain areas, that means that they're going to disproportionately police areas that have high populations of people of color versus other neighborhoods that might have similar crime or drug rates but are not minority neighborhoods. So again, it's easy to see the results of the system and say, look, more people of color must be committing more crimes because more of them are in prison. When we look at how crime operates and how deviance operates, we find that it's not as if the crime is different, just the amount of arrest is different. Okay, so she argues that the system operates in a few stages, right? So the first stage, she says, is discretion, meaning that, you grant law enforcement personnel extraordinary discretion as to whom they get to stop, who they investigate further, who they arrest, and who they charge. So this allows beliefs, stereotypes, policies, and assumptions that come from, a person that could be influenced by the cultural perception of racism, to unduly influence the decisions that they make. And of course, there's obviously an influence of stereotypes on policy itself. So there was a racialized nature within the war on drugs, with especially the crack epidemic, which led to this unspoken racial bias that morphed itself into policy. So why else are there discrepancies in the sentence for crack cocaine versus regular cocaine, right? If it doesn't have to do with the the messages that were in the media about this being largely a low-income people of color using this drug, right? If it wasn't associated that way, would it have been considered as deviant? Would there have been a 100-to-1 rule? And then the second stage, she argues, is to disable the ability of court systems to consider the claims of racial discrimination in the criminal justice system. So she says that they do this by requiring unreasonably high standards of proof. So it's been accomplished by, basically you have this situation where it's so unreasonable, the standard of proof that you have to prove, that it's almost unattainable in all cases, because you have to prove that an official was intentionally racially discriminatory, meaning that they had bigotry or racial hostility as a motivation for their actions. So instead of allowing a demonstration of clearly discriminatory outcome of the legal process, showing how, like, if two people enter the system and depending on their race, they are much more, like, 57 times more likely to end up in prison, then that should be enough on its face to kind of argue that there is some racial discrimination going on. But instead, they changed this to say that you have to somehow prove that an official had an intentional racial discrimination. Again, a lot of us don't, unless we're taking sociology courses or things like that, the humanities, we don't question the things we've been socialized with, right? A lot of us just don't think that we're prejudiced. We don't think that we're putting these kind of influences on what we do. But of course, we are shaped by gender, class, race, sexuality, ability, age. All of these different things have different meanings. And of course, it's a lot harder to prove that someone intentionally discriminated against you versus that they, that the consequence was discrimination. Right? So basically, it turns out to be extraordinarily effective because the promoters of this system of racial control can say, look, it's colorblind, but it's damaging for the people in the population that are subjected to it because they can't point out that they are being racially discriminated against, because they have to basically prove that the person willfully did so. Like, kind of like the O.J. Simpson case of, the whole reason that, like, a lot of the doubt that came from that case was because one of the officers on the case, Mark Furman, who's now this is insane. He's a police commentator for Fox News now. He was, like, fired because he couldn't stop saying the N-word, and because he planted evidence in the O.J. Simpson case. So he became the reasonable doubt for whether or not O.J. committed a crime, right? So again, it'd be easy with Mark Furman because he literally would not stop saying the N-word to be like, oh, he's racist, right? But it's very difficult if someone doesn't say explicit racialized language to kind of prove, even though what they're doing has that consequence. So of course, she talks a lot about the war on drugs, how there was a shift from treatment to policing when Reagan revved up the war on drugs, that the focus shifted and the funding shifted, right, from drug treatment to, and drug education, to more of this enforcement and policing, and not as much prevention, education, or programming. And there was a lot of consequences to that. So also here I put a bunch of clips about how the media was responsible for the proliferation of the Reagan-run war on drugs. So their message was that drugs, especially crack cocaine, were dangerous and could kill you. And they argued for the legitimacy of the drug war on moralistic terms, meaning you had to protect children, you had to protect women, you had to protect white communities from the plaguing nature of these inner city poor communities, right? Which led to a public conception of drug users as, deviant, as racialized, those kind of things. So in these video clips, I have a ton of these clips here. I'm not going to show them all right now just because a lot of them are in the film, or portions of them are in the film that we're going to watch in class 13th. But there's a few like drug PSAs. There's a long clip here, like over an hour, where it shows a bunch of different footage from the war on drugs policing time period, so that you can see how people were shown on television. So it's not just me saying it or her saying it in the book. You have plenty of proof there, and a couple other media campaign things that are related to that, such as, like I said, PSAs and like Just Say No, and the specific speech that Reagan and Nancy gave about the drug war. So that's all on there, but we will see portions of it in the film, so I'm not going to include it here, but you're of course welcome to watch it on your own time. And of course, this established racialized public perceptions, because when you see the same message over and over and over and over and over, we know media has a coercive influence as a form of social control on how we understand and see the world. So news reports focus on urban offenders in inner city areas when we know statistically drug use is about the same across racial lines in all neighborhoods, yet the majority of people featured on the news as addicts being arrested by the police in crack houses were people of color. So the subtle argument that a group of people are experiencing a sort of social decay due to the introduction of crack cocaine became the justification to hyper police these areas. And so, of course, it's not as if just people in law enforcement are watching this, right? All these kind of perceptions on TV. It was juries, judges, police, politicians, prosecutors, all the people who inhabit those jobs and roles. They're also people outside of those roles, right? So this racialized ideology of the time permeates the social understandings, and these stereotypes affect people's perceptions of whether someone's good or not, or whether they should be charged or sentenced or not. So, this is kind of the details I was talking about before. So in 1938, the Supreme Court recognized the need to protect, quote, discrete and insular minorities. So the Supreme Court recognized at this point that they needed to protect the rights of minorities who may not have popular opinion on their side, but need representation and protection. So one of these cases, Wren v. United States, that kind of went on the back of this 1938 case, was a case in the 90s that changed the court's ideals of protection of minorities, instead opening up opportunities for police stop and search procedures, even without a presumption of criminal activity that was likely to have occurred. So this was upheld and declared not in violation of the ban on unreasonable search and seizures from the Fourth Amendment. So the lack of such likelihood requirement allowed unlimited racial discriminatory discretion on the part of police. So the court also barred the accused from claiming racial bias under the Fourth Amendment. Using the 14th Amendment for this purpose was formally allowed, but the Supreme Court had already effectively eviscerated that avenue for seeking legal redress in an earlier 1987 case, which was called McCluskey v. Klemp. So this 1987 case alleged racial bias in Georgia death penalty practices in violation of the 14th and 8th Amendments, and was claimed by the defendant based on the extensive study of Georgia murder cases that was done. And so Georgia prosecutors were found in the study to be disproportionately more inclined to seek the death penalty when the victim was white and the defendant was black, rather than the other way around, which was 70% to 19% respectively, which resulted in defendants being charged with the killing of white victims. They would receive the death penalty at a rate 11 times higher than defendants who were charged in the killing of black victims, which, was only like 4.3 times after adjusting for a number of non-racial variables. So black defendants found guilty of killing white victims were the group most likely to be sentenced to death, right? So the case, though, brought up like a whole other can of worms that upset prosecutors. So basically, they were worried that if this case went through, right, and you were able to use statistical evidence to prove that racial discrimination was happening, that this would undermine the entire U.S. criminal justice system practices. So the court protected it from claims of racial bias by ruling that statistical arguments alleging patterns of discrimination in court decisions did not prove unequal treatment and therefore could not be used in legal challenges, and that conscious discriminatory intent on the part of the plaintiff officials must be demonstrated. So this requirement of proving deliberate official bias in each individual case, which is pretty much impossible to satisfy within the existing trial procedures unless someone yells out a racial slur, has rendered challenging court racial discrimination under the 14th and 8th Amendments impractical. So claims of bias were shot down in fear the system itself would be paralyzed with challenges, right? If they allowed this to go through, would not the overwhelming 80 to 90% in some states of defendants try to use these defenses, right? So another case that followed this was United States v. Armstrong. This case was about the fact that out of over 2,000 crack cocaine federal prosecutions in California, none, according to the government, in a 3-year record were against whites, who were the majority of crack offenders that were, believed to be white. So the discovery could point to the selective prosecution, meaning there's a switching by federal prosecutors of white offenders to the state system where their crack penalties are less severe and they would get less sentences. That was being suspected. Like, why are there so few white people in this system? So, basically, they said this was granted by the district court in California, but it was denied by the U.S. Supreme Court, which felt that, deference to the exercise of prosecutorial discretion must be kept intact at the expense of non-discriminatory treatment of the accused. So the court protected discretion of prosecution includes the domains of charging, plea bargaining, transferring cases, and sentencing. So meaning they're still giving that amazing amount of power to prosecutors. So studies have shown that in prosecutor-controlled pretrial negotiation processes, whites are far more successful than non-whites. But again, apparently statistics don't matter within this system. So, sorry, I keep having a hard time saying it. Prosecutorial discretion includes the ability to transfer cases from state to federal system or the other way around, to transfer juveniles to adult courts. So often African-American minors, who account for about 16% of all youth in the U.S., are almost 30% of all juveniles arrested and 35% of those redirected to adult and criminal courts. And they end up being 58% of all minors admitted to state adult prisons. So differential treatment of white and non-white youth by prosecutors who have fought against and are protecting from any judicial checks or scrutiny by the Supreme Court is one major cause of these disparities. So basically, she argues that the U.S. Supreme Court, according to Alexander, devised a system which appears to be colorblind, but in which racial biases and stereotypes are given free rein. Okay, so as far as jury of your peers, first she talks about the racial composition of juries. So black defendants who go through criminal trials may end up before a jury, right? Even though we know the overwhelming majority of cases are settled through plea bargaining. But the selection of jurors and racial composition of juries have always been of great importance to the accused. So there's a couple cases she talks about in here. The first took place in 1880, Strouder versus West Virginia. So basically, the U.S. Supreme Court, based on the then recent 14th Amendment, adamantly rejected the automatic exclusion of blacks from jury duty based on race. In reality, however, convicting of African Americans by all white exclusionary juries had remained a regular practice throughout the South, and the outcomes of these trials were held up by high courts on a number of occasions, with the exception of a couple cases in the 1930s. But, obviously, giving equal protection under the law meant you could also serve on a jury, but that often wasn't the case. A lot of people of color were dismissed from juries. So the Swain v. Alabama decision, another Supreme Court, where the Supreme Court provided insignificant protection against all-white juries, allowing for racially motivated challenges on the condition that a given prosecutor had not always excluded blacks. So this result was overruled in 1986 in Batson v. Kentucky, when, based on the 14th Amendment, a bunch of jurors, basically based on race, they figured that the selection process was unfair because it was basically they were excluding on purpose people based on race, and so they prohibited that. And the ruling, believed at the time to be of fundamental importance for the rights of defendants of color, has subsequently been practically compromised by that prosecutorial practice and further court decisions that have accepted the circumventing strategies. So, there are protections that were put in place through this challenge to Swain v. Alabama, but at the same time, there's just ways that people have been able to get around it, and those have been solidified into law. So the pool of available black jurors has already been severely limited because the government lists from those which jurors are picked are typically registered voters or vehicle owners. And, the widely applied, exclusion of felons from voting, often for life, is a big part of why African Americans are kind of already disproportionately low in the jury pools. So, to remove the most of the remaining African Americans, the prosecutors now had to come up with race-neutral explanations. So, sure, there's still going to be people that weren't convicted in the system, that are registered to vote, that are car owners, and so now they had to figure out a way to get around this. So, Perkett v. LM was where the court accepted the plausibility of using trivial or arbitrary excuses for excluding jurors. So as long as it wasn't racially based, you could use all sorts of crazy reasons, right? So this let the trial judge rule on the validity of reasons given for each challenge. So since that time, federal courts have tolerated many cases of practical or informal exclusion of blacks from juries. So another example she gives in the chapter is Miller v. Cockrell of 2003 was an exception because a jury selection manual with racial criteria was found to have been used, which violated this, standard of condoning discrimination. But basically, the policy, if it's not explicitly stated, they can just say like, oh, I'm not dismissing this person because they're African American. I'm dismissing them because they're left-handed, and left-handed people would be prejudicial towards blah, blah, blah. Right? So they'll be like, it's because this guy's wearing a purple shirt, and people that wear purple shirts have been psychologically shown to blah, blah, blah. So they'll just pick some bizarre reason, but it's still a way where you can still systematically exclude people based on race. Alrighty, so, the research from the University of Washington, there was a team of researchers that found that police priority enforcement of minority neighborhoods and actions preferentially directed against members of the Black and Latino ethnicities could not be justified or explained by the phenomena conventionally claimed to be responsible by defenders of government drug era policies, such as high rates of drug offending, accessibility to open-air drug markets, crime rates, violence, citizen complaints, etc. So police stereotypes and the assumption that drug dealing and usage of crime typically occur within the minority communities, combined with the perception that crack associated with urban blacks was the single most important culprit, resulted in a situation where whites were not perceived as drug offenders by Seattle police officers, because remember this was done by the University of Washington, and the department members therefore directed their law enforcement efforts in accordance with this politicized, racialized conception of the drug problem. So, a lot of research has looked at this at university level to try and understand why is it that the outcome seems to be so discriminatory, right? And it's because of the practices themselves. So also these unreasonably high barriers and procedural requirements. So the issue is the standing requirement where you have to prove that you can sue under this category, meaning you have to have physical evidence of intentional racial bias, something almost impossible to produce. So another case that she talks about is the City of Los Angeles v. Lyons, where the plaintiff sought to force the Los Angeles police to discontinue a violent procedure that he was subjected to and others had been killed by. But in 1983, the Supreme Court declined and established the normally impossible to meet standing requirements that have since prevented or discouraged further legal challenges to even obviously illegal and discriminatory police practices. So in a series of rulings, the Supreme Court has also declared state institutions immune to monetary damage suits and greatly restricted the, applicability of such lawsuits. So this proved that intentional discrimination is required in the case of local government units as well. So that's a big problem when we have police procedures like, there was a very high-profile case of police brutality where a young African-American man was placed in the backseat of a car, and when he was dropped back off, his spine had been severed. And what happened as a result was they basically, and this was a common procedure in the area where this happened. We'll talk about this later. She gives a specific case later on, and they talk about it in the film. But this man was basically put in the backseat of a police car without any seatbelt. And then they drive around and just kind of whip the back of the car around so that the person in the back seat goes flying around and hurts themselves, right? Gets hurt. This was actually a practice that the police had been sued for before, because it had resulted in a miscarriage of a pregnant woman, right? That this was done to. And the sad part was that same kind of thing when this man, when his family, because he died as a result of his injuries, tried to sue. They were basically told that unless they could prove that it was a discriminatory police practice, that, the burden was on them to prove that, even though, his spine was severed from being thrown around in the backseat of a police car, right? So obviously it has something to do with the procedure that's going on there. So this is still an ongoing thing, even though these are a lot of older court cases that she's talking about. They laid the groundwork for what kind of challenges people have in the modern day. All right, and then the case of United States v. Brignoni Ponce. Basically, in this case, this was actually a California-related situation where a guy was driving. There used to be kind of these mandatory checkpoints in San Clemente. Like if you're driving, like I have a lot of family that lives kind of south of there, so if you're driving back, you see the checkpoints. And basically, what happened was this guy was stopped and pulled over because he was of Latino descent. And it was found out that two of his passengers were undocumented. And so he was charged not only with, he was charged with a crime for basically transporting two people that were undocumented as if he had willfully done so. So basically, what happened was he used the defense that the only reason he was pulled over, which was a violation of the Fourth Amendment, was because of his, Latino heritage. So, the Supreme Court basically said that's true. There was no other probable cause. He didn't even commit like a traffic violation as a pretext, as a reason to pull him over. So there was no pretext. So therefore, it wasn't a fair stop because you can't just stop someone because of their race, right? You have to have at least some sort of idea of what they did, criminally before you have the ability to stop them. So that is a case that kind of, again, there's still ways to get around this, right? So numerous studies have looked at how there's a dramatic pattern of racial bias in situations like traffic stops where racial minorities do not numerically predominate prominently in highway patrol stops and searches. So African American Latino drivers are stopped and searched in disproportionate numbers and consequently constitute a large majority of those arrested and charged with drug crimes. So there's no positive correlation between the frequency of occurrence of drug violations among racial groups and criminal charges filed by the police. The relationship depends on the makeup of motorists, right? And of course, stop and frisk is another one we've talked about quite a bit that's come out through this, this pedestrian stop and frisk tactics that were widely practiced by police in New York City and other municipalities, targeted blacks and Latinos at the rates much greater than white pedestrians, and likewise contribute to the racial disparate proportions among those charged with drug crimes and those who end up in prison for drug crimes.